Good evening. Today I am going to teach seminar on the case People's Union for Democratic Rights versus Union of India, cited 1982 AAR 1473. This case talks about how an organization named PUDR, that is People's Union for Democratic Rights, which works for protection and welfare of the democratic rights of people, filed a PIL against the state because they were negligent in providing daily minimum wages to the laborers and failed to provide a healthy working environment for the poor. They were suffering but were not in a position to approach the court, so this organization, after analyzing and interviewing various workers, filed the petition bona fide intention. Here, there is violation of Article 21, 23, 24 of Indian Constitution, the Minimum Wages Act 1948, Contract Labourers Act 1970, Equal Remuneration Act 1970. Now, let's look at the facts of the case. PUDR is an organization which is working for the protection of citizens' democratic rights. It is observed that the workers who were working on the ACR 82 project were not given healthy environment and were not provided with daily minimum wages. They have to work at sites both on stadia and infrastructure like hotels, flyovers, etc. The workers were forced to complete the project as soon as possible and they were termed as beggar as they were recruited by the construction contractors without having fixed hours of working and were not being paid. Because of this, their children lacked basic necessities and were forced to be malnourished and became the victims of the accident. PUDR, an organization which works for improving the working condition of citizens and to provide their rights, employed 3 ombudsmen whom after analyzing could bring out the report on the exploitation of and living condition of the workmen working under the contractors employed by Union of India. PUDR visited major sites and interviewed many employees and then filed a writ petition before the Supreme Court on November 16, 1981. By way of PIL, it requested to issue observance of the provisions of various labour laws in relation to the workers employed on the construction work of ACR 82 project. The scientists were to submit weekly reports to the Honorable Supreme Court relating to the cases of violation of the law. Now, let's look at the issues of the case. The first issue was whether the writ petition can be maintainable against private individual under Article 32 of the Constitution of India. The second issue was whether Article 21 of the Constitution of India also include right to live with human dignity and right to livelihood. Arguments from the petitioner's side. The petitioner argued that the contractors engaged the workers through jamdas who brought them from different parts of India and were not paid daily minimum wages. They have to be paid 9.25 per day but were only paid 8.25 per day and 1 rupee was being detected as commission for the jamdas. Hence, they violated the provisions of Minimum Wages Act. There was violation of the Equal Remuneration Act 1976 as female workers were paid less and their wages was misappropriated by the contractors as they got only Rs 7 per day. Article 24 was violated as the sites engaged children below 14 years of age to work in factories and mines which are hazardous for them. The provisions of Contract Labour Act 1970 was violated, which resulted in the exploitation of workers as they were not provided with the facilities and they were deprived of their proper right of living conditions and medical related facilities. Article 23 was also violated as the labourers were not given their daily wages which they are entitled to do and so were forced to forced labour. If they were not getting less than the minimum wages, their work will be considered as forced labour or termed as beggar. Arguments from the respondent's side. The respondent claimed that the petitioner was in no position for locus standi in which they filed the writ petition as there was no violation of the rights. It was the labourers whose rights were infringed and they should have filed the petition because there is no cause of action arose for the petitioner, that is PUDR. The respondent argued that the workers were actually directly employed by the contractors and not the respondents, hence they are not liable for the violation of their rights. The Employment of Children Act 1938 is concerned, the Union of India, the Delhi Administration and Delhi Development Authority was that no complaint in regard to violation of the provisions of the Act was at any time received by them and they disputed that there was any violation of the same. They also contended on behalf of the authorities that Employment of Children Act 1938 was not applicable in case of employment in the construction work of these projects since construction industry is not a process specified in this schedule and does not come within the section 3 of this act. Now let's discuss the judgment of the case. It was held by the Honorable Court that the right of a poor worker to directly approach the Supreme Court under Article 32 of the Constitution of India for the enforcement of rights created under various labour laws and particularly under the provisions of Contract Labour Act 1970, Interstate Migrant Workers Act 1977, Equal Remuneration Act 1976 and Minimum Wages Act 1948 were correct. The court said that if the violation of labour laws are to be punished only by mere fines, then it is not possible to maintain the strictness and ensure observance of the law, as the people will become reluctant because they have to pay very less in terms of the crime they have committed. The laws would be mere tigers without claws or teeth. The petitioner presented that it is true that they were not in a position to file the writ petition as they were designed for the welfare of the workers. So it could only be the labourers who could file the petition because they whom the legal injury has been occurred and they should approach the court for the redressal. But the traditional rule of standing was a result of inheritance of the Anglo-Saxon system of jurisprudence, which is now broken, and the doctrine of locus standi is in its due dimension. As there are many socio-economic conditions prevailing in the country which is faced with poverty, literacy, ignorance, disability, it deprives the poor to approach the court and fight for their rights in order to get justice. Thus, any member acting in bona fide and out of extraneous motivation may move to court for the redressal of legal injury suffered by the persons who cannot fight for themselves because of their condition. The petitioner is an organization who works for the protection of the rights of workers, thus it is clearly maintainable. The petitioner says that although it is true that the workers were the employees of the contractors, this cannot escape the obligation of the respondents to keep a check on various labour laws and their enforcement. So far as the Contract Labour Act 1970 is concerned, it is clear that if any benefits of the workman employed in an establishment is not provided by the contractor, such obligation to provide such amenity rests on the principal employer, and therefore even the construction work of the Asian project, the contractors do not carry out the obligation imposed upon them by any of these sections. The Union of India, Delhi Administration and Delhi Development Authority as principal employers would be liable, and these obligations would be enforceable against them. In section 17 and 18 of the Interstate Migrants Act, the principal employer is liable to pay the migrant worker their daily wages if they fail to do so. The mines employed children below the age of 14 years in hazardous work which are harmful for the children, and it is also the duty of the respondents to make sure that this obligation is being followed by the contractors. The respondent presented that the petition was not maintainable under Article 32 of the Constitution unless some breach of fundamental rights being present. The petitioner for that presented that Article 23, which is clearly designed to protect the individual and prohibit traffic in human beings and other forms of forced labour and beggar. It is not merely beggar which is being prohibited by the Article 23, but also all other forms of forced labour, as it is violative of human dignity and contrary to basic human values. Therefore, it violates Article 21 as well. The court held that Article 21 means right to life, which also include right to live with basic human dignity. We may add that whenever any construction work is being carried out, either departmentally or through contractors, the government or any other governmental authority, including public sector companies, which is carrying out such work, must take great care to see that the provisions of labour laws are being strictly observed. The legal aid movement and public interest litigation seeks to bring justice to these forgotten servicemen of humanity who constitute the bulk of citizens of India, who are really and truly the people of India who gave to themselves this magnificent constitution. It is true that there are large arrears pending in the courts, but that cannot be any reason for denying access to justice to the poor and weaker sections of the community. Thus, the court held that the petition is allowed, and the court correctly held that Union of India, Delhi Authority, should not escape from the obligation to ensure the observance of labour laws, whether or where they are not violated, and if so, they should take action against the same. Now, I would conclude the seminar by saying that this case depicts that rule of law does not mean that its protection will be given to only fortunate people or only those people who can approach the court, but poor people too have civil and political rights, and rule of law is applicable to them as well. Some of the fundamental rights can be enforced even against private individual, and it is not that the private rights can only be enforced against the state. Private individuals are held responsible if fundamental rights are violated under the Constitution of India. This case law provides important knowledge about various laws and their interpretation under the Constitution of India. It provides an in-depth knowledge of the judicial interpretation of the word life under Article 21 of Constitution of India. Thus, the court by their power create and interpret for the benefit of general public to do full justice words which, if not interpreted, would remain ambiguous or be limited to a mere definite meaning. Thank you.